Welcome once again to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program had been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that may help you decide that you may be able to handle some issues yourself. If you do, you'll be better prepared. We hope that if you select outside counsel, you can help them be better prepared, and together you can achieve the best possible results while saving time and money. Today's topic, alternative dispute resolution, mediation, arbitration. At times, litigation can be avoided. It's known to be costly, unpredictable, unwieldy, certainly draining and emotionally draining and difficult to deal with. At many times, people don't want to rely on having a judge to decide the case. So at times, while that can be inefficient, we're going to discuss and explore today ADR, as it's called, and see how and if it might help you. There are times when you may find that that is just a better solution for you. It's certainly become increasingly popular. So what are the benefits? What are the restrictions? What's the process? How do you get there? How do you get to what is a reasonable, win-win, acceptable result? So we're going to ask, as we usually do, welcome and thank David Bizarre from the Bizarre & Associates law firm in East Providence, who continues to weigh in on our issues. So David, please give us the tutorial on what is called ADR, arbitration, mediation. Perhaps mediation is easier to discuss, but...
Well, alternative dispute resolution is, as it says, alternative to court and trials. So in many instances, if you file a lawsuit, the court will require you to try, at least at one point in time or another as the case is progressing, to resolve it short of having a trial. That's true in family court in Rhode Island. Many cases require mediation. All of them invite mediation. Superior Court, all the cases that you file, that not all cases, but almost all cases require arbitration at some point. And in federal courts, they do the same. So it is an opportunity to avoid, the cost and expense of having to go to trial.
You mentioned that it can be done, in many cases, they would have to be non-criminal. They can be personal, they could be business, but can they be criminal cases in any situation?
Well, we're certainly mostly here talking about civil cases.
Yes, okay.
So it's family court civil cases, superior court civil cases, and district court civil cases.
So mediation versus arbitration, how are they similar? What are the differences?
So the main difference between mediation and arbitration is an arbitration is sort of like a dry run to a trial or a less formal trial, and it can be binding or non-binding, and the person who's hearing the case or the panel, it can be a 3-panel arbitration or a one-person arbitrator, they decide the case and they give you an award or a finding. In mediation, the mediator does not decide the case. The parties are the ones who agree or don't agree to settle the case. All the mediator is trying to do is to bring the parties together.
So in mediation, if the parties who are in dispute, whether it's a divorce or whatever, or business situation, what results ends up being non-binding, but it is a new contract. What are the differences? How do you deal with that, David?
Say that again?
So if it's something that two parties agree to in mediation, is what that final document becomes, is that a binding contract?
So when you go through mediation, at the end of the process, depending on what type of mediation it is, there'll either be a memorandum of understanding, which is the result of your agreement in mediation, which if it was in family court, for instance, you would then bring to an attorney to turn into a property settlement agreement or a marital settlement agreement or some type of agreement that is a contract. If it's a mediation of a lawsuit, an automobile accident, for example, at the end of the day, if you have agreed on a number to settle the case, the mediator will oftentimes do a dismissal stipulation of the case and an agreement that you sign at the hearing, at the mediation hearing, so that it is kind of finalized because you've dismissed your case as a result of your agreement.
And at that point, do you have any recourse? Could you still say, I'm not really sure I like that bottom line. I think I'll take it to court. I think I will go to trial. Can you do that once there's mediation?
You can say that you don't agree at the end of mediation and go to
Okay.
court. But if you've agreed at mediation, you've signed an agreement and you've dismissed the case, then it's going to be pretty difficult to get that set aside.
Okay. Go through, if you will, the process of mediation. And for the sake of argument, I understand that it's quite common with divorces. And apparently, the latest statistic that I read was that 50 to 80% of people who go through divorce mediation say that they're satisfied with the outcome, which is certainly encouraging. And it seems like that's something that the courts will want, considering how congested they are. So what's that process like, David?
So 2 things on that. On family court mediation, I would agree that most people will end up being satisfied to some degree because it's their agreement. In settling civil cases, we sometimes say both parties are not, they're happy to have the case settled, but they're not pleased with the result. And so if both sides aren't pleased, they say then it's probably a good thing that the way the case worked out, because
It's still be a win-win, but even though each
Yeah.
one isn't entirely
No,
satisfied.
neither one's entirely satisfied, but they've resolved it. And that's the thing about mediation, is it's the parties that come to the agreement. So there's more control by the parties, and they feel more part of the process and the result. So there's usually more buy-in. And that's why it's very successful in family court situations, where you've gone through this whole mediation process and the parties have resolved it rather than the judge. And in sending people to mediation, judges will often say to the parties, I think you two should go work this out with the mediator rather than having me, some person who's happy to decide the case for you but doesn't know you or your children or the situation as well as you do.
So how would a divorce or divorce in child custody mediation process take place?
So the process of mediation is, first the mediator will generally meet with the parties
Together?
together and explain how mediation works, what the process is, and what's expected of each of them. And then, after they've gone through that, the parties can together explain to the mediator what their concerns are. But then the mediator will break them up into separate rooms and talk to each of them alone so that they can be open and honest about what their concerns are, what they want to share with the other side, and what they're willing to do to come to a resolution. And then the mediator is sort of like a shuttle diplomat, shuttle diplomacy going back and forth.
So I understand that this should be a shorter term process than what litigation would be. How many occasions or how many times do you need to meet? You said initially there's one when the two are together, and then you referred to times when you might put them in 2 separate rooms. How many different occasions might you meet? And I'm sure it depends on how far apart you are and how close you can get them, but is there an idea?
It depends on how far apart they are, the complexity of the issues, and
Yes.
how many issues there are. So in a family court case, for example, there could be issues about equitable distribution, dividing up the assets. There could be issues about the children. There could be issues about health insurance and life insurance and all sorts of other kinds of issues that can come up in a family court case. So in that type of situation, you might need several sessions to get it done because, first of all, you might not be able to get to all of the issues in one time. And second of all, if there's a lot of disagreement on some things, it might take longer to resolve each issue. In a personal injury arbitration, for example, it's really about whether or not we're going to come to an agreement on what the injury is worth and what the liability is. So oftentimes those can be resolved in one day, or if it's a complex kind of case, a couple of days.
Now that's interesting because theoretically when you're doing mediation, you would assume that the people who are coming together want to work it out, have something that's reasonable, equitable. Perhaps they can hold their temper or contempt or whatever their emotional issues are. They can keep them in check and discuss things. But arbitration, isn't it that by nature always something that's adversarial? So it's interesting to think that that could be resolved in one session.
Well, we're talking about mediation. Arbitration is how long does it take to present the evidence?
Just the evidence, okay.
Right, because
okay.
that's all you're doing there is you're presenting your evidence and you're arguing your case. Then the arbitrator has to decide it. So just like a trial, if it's a lot of complex information, it could take longer than one session or one day, but oftentimes it's streamlined, so certain things have been agreed to beforehand so that you don't have to prove those types of things. The evidence usually can come in a less formal way, and the parties exchange all their information usually before the arbitration, so the arbitrators had a chance to go through it and maybe streamline the process and asking questions and saying, I need to know more about this issue or that issue.
So if you're in keeping with arbitration, I understand that mediation is always confidential. Is arbitration and its outcome always held close to the vest and confidential as well, David?
Not necessarily, and it depends on the situation.
Yes.
A Superior Court arbitration that's part of the Rhode Island Superior Court arbitration program is not admissible into the trial. What happened with it is on the public portal, so people could be able to see it, the judge could see it, but it's not allowed to be anything that's introduced at trial for a jury to see, for example.
Okay. Flipping back to what mediation is, does each person who comes to you, say in a family court situation, does each person come with already what they consider to be just and only what they want, and then, or is that something that you try to have evolve? Do most people come in, this is what I want, David, help me get it, if you're the mediator, for example?
Yeah, many people come in with a preconceived notion of what's fair and what they're willing to do.
Yes.
And sometimes they're right, sometimes they're wrong, but oftentimes it's a matter of taking them from where their position is and where the other side's position is and trying to examine with each of them why that's their position and why it might not be so fair and reasonable. One thought that comes to mind, and a lot of what mediation, especially in family court's about, is getting the parties to talk to each other.
Yes.
So one of the results of mediation in family court cases is people could end up being able to speak to each other better after the mediation than they were able to before. They can communicate because we try to teach them to listen to each other. And a lot of a catchphrase that a mediator might use, did you hear what Mrs. Jones just said?
You say,
This is what I heard. Is that what you heard? Or is that what you meant, Mrs. Jones or Mr. Jones? So there's a lot of repeating back so that people learn to hear and listen to what's being said. So it reminded me of a case once where, let's just say mom wanted dad to have some time with the children on a Wednesday after school and bring them home after dinner. And dad wanted to do that, but on a Tuesday. And they were back and forth. And what was the difference between the Wednesday and the Tuesday? And maybe for dad, he had an obligation every Wednesday night that he couldn't get out of. He could easily do it Tuesday. And the mom said, oh, I thought the obligation was on Thursday. I didn't realize that. Yep, Tuesday's better for me than Thursday, so let's do that, or whatever. And they start talking to each other about why they hold the position that they hold and why they're thinking what they're thinking. And as long as they're not doing it to be vindictive and mean, but there's a reason, oftentimes you can discuss the reason rationally and logically and come to a resolution that is better for both sides.
Good to know. So we know, David, that you're an attorney. We also know, some know, that you are also a mediator. When two people come to you and say, there's a divorce that's going to happen, David, would it be you who would ever initiate and say, do you want to mediate this, or do you want to have me represent one of you, or how does that play out? What are those typical conversations,
Well,
David?
if someone contacts me, and wants to make an appointment for me to represent them in a divorce, then I can't be the mediator.
Could you say to them, do you think this is something that that could be mediated? Would you ever have an occasion to say that first?
You could do that if they haven't hired you yet. They're just calling to make an appointment.
Okay, good distinction.
And they're saying, I'm thinking of getting divorced. I'd like to come in and see you. And you could say, well, is this something where you think mediation would help? Because you and your spouse could make an appointment and come in and see me about mediation, but then I couldn't represent you if it became a divorce? Or is it just you're not going to be interested in mediation and you're just looking to hire an attorney for a divorce? That would be a different situation.
And yes, you are both, but you can't serve as both. Not all mediators are lawyers, but theoretically, could all lawyers, I assume all lawyers could easily be mediators. They may not choose to, but.
You could be trained to be a mediator and you could serve in that function. You're correct, all mediators you do not have to be a lawyer to be a mediator.
And mediation is less costly, we've understood that. When someone is thinking about having you as a mediator, yes, you have the body of knowledge which makes you a lawyer. Are you able to give them, let's see, that distinction would be, are you able to give them legal information as opposed to legal advice? And can you explain that distinction? Because I think it's an important one.
It's a very important point. You could give them legal information. You can't give them advice because you're not representing either of them as an attorney. You're a mediator. And depending on the complexity of the case that's being mediated, oftentimes you'll tell your client, or the clients for the mediation, you should speak to an attorney before the next session, and here are the issues that you should raise. So you're giving them some legal information about things they need to talk to an attorney about and to get advice. Just like you would say to them, if the issue were the value of the house, you should speak to a real estate appraiser or broker and get some information about the value of the house. Or if it's about a stock account, talk to the stockbroker and get some information about the stock account. So we're often advising our people who are going through mediation that there's a list of, a stable of professionals that they may want to seek advice from before they come back to the mediation, whether it's an attorney, an accountant, a stock advisor, a real estate broker, somebody who has information or expertise in an area that they really need to know more about before they continue with the mediation.
And if they haven't done this, David, and you see something that makes their suggestion or their proposal really not reasonable for them on either side of it, might you say this isn't going to work and I suggest that you see that account? I mean, would you likely say, this isn't going to fly, this is not acceptable? Would you be saying that before it goes to the rubber stamp of approval?
So in mediation, one of the things you're trained as a mediator is the parties can agree to anything they want to agree to so long as they understand what their rights are. And I think the example that was given to me was you can give away the farm as long as you know what's on the farm. And so if someone is making an agreement that is, very unfair on the surface, or for whatever reason you think it's unfair, I as a mediator wouldn't tell them, you can't do that. I would tell them, before you can agree to that, you need to speak to, whether it's an attorney or whatever else, just so you know your rights, because you're allowed to agree to whatever you want to agree to, but you have to understand your rights and you have to know what it is that you're entitled to.
And you are giving them information that they may not know all that they need to know to make an informed decision, as they say.
Right. So, for example, let's just use family court. When they start talking about child support, you would be able to tell them that there is a child support guideline that calculates through a formula what child support's supposed to be. Now, what they want to do with that is something different.
Let's see how I want to phrase this. How could the person who is hiring you to serve as a mediator, how could that person enhance the outcome or the position? So is it fair for them to say to you, could you give me some insight as to what you would deem to be reasonable? Can you do that?
Well, if the two parties ask,
If they're, so, okay, if you're in joint session first, and then what about if they're in individual caucus? So how does that
yeah.
work?
So if you're in a joint session, what I usually would be doing is laying out what all the issues are that they need to think about. So if it's family court, there's issues about custody, placement, visitation, parenting time, child support, alimony, equitable distribution. Those are all of the things that they need to think about. I'm not at that point giving them any advice as to what they should do. If we've met and we've gone back and forth and now they're asking me, well, what do you think is fair? I'm going to go back to them and ask them, well, what's fair to you?
So
What do you need? What do you want? Why do you need it? And at the end of the day, it's not really my job to advise them as to what's fair or not fair, although I will try to guide them to something that's fair. But if they need advice, then they need to get it from a professional.
So let me press you on that just a little bit and say, David, this is what I think I would like. Do you think that my soon-to-be ex would find this offensive? Can you answer that?
Yeah. So as part of mediation and how you're going to present things, the mediator can help frame things so they're not presented in a way that would be offensive to the other party and be an immediate end of mediation. So if you said to me, this is what I really want, my concern is what the reaction is going to be to this, then I would say, okay, well, thank you for that information. I'd go to the other party and I'd say, well, what are you thinking? And then maybe present the thought of what you're saying, not necessarily as, well, this is it, we're done, whatever, but, well, what would you think about this? And how would you react? And what would you want me to take back to the other side? So you can tell me, I need, if it's equitable distribution, X number of dollars and that's it. Well, it's never that's it. But tell me why, tell me what information that's around that is to what informs that decision. And maybe I can take some of that information back to the other side and say, well, do you think your spouse needs this because of this, this, and this? And how do you feel like we can accommodate that? So
am I hearing you say that someone would approach you by essentially building a case that they're presenting to you as, David, this is the amount and this is why. So they're actually, in some ways, building their case with supportive documents or information, and to some extent, I guess, convincing you that this is valid, reasonable.
Well, they're not necessarily going to convince me of anything.
They might not know. I don't.
And I don't need to be convinced of anything. But they usually won't even tell me why, and I have to dig in on the why.
You have to, okay.
And usually. And the why is important because that's part of what you want to bring to the other side so they can understand why it might be reasonable.
So while we're talking about this in the context of a divorce situation, if you were doing mediation and it were for a business, similar scenario, we're dissolving our business, we have a dispute about the business, this is what I think is fair and this is why, similar thing would go on, and you would be, again, the same person who would be couching it or presenting it or contextualizing it in a way that is palatable to the other?
Or at least to get a response to it and maybe a counter. But in a business, just like in a divorce or any other kind of mediation where there's some expertise that's going to be necessary, when they say I need this, this, and this, and I might go back and say, well, what does the accountant say the result of doing that would be? We need to know that before we continue on. So again, in any of those other types of situations, just like family court, having the input and advice of experts may be very necessary.
Okay. Before we go to talk about arbitration a bit, just say no. Do you have an occasion to advise either party that they have a right to say no, that this just isn't what that person finds reasonable, and we really need to take it to that next level, litigation or whatever? Do you advise them, or do you present that to someone so that they understand clearly that they don't have to accept this?
Yeah, so again, I'm not really advising. I'm sort of letting them know how mediation works, and that not all, here's the thing, almost all my mediations are successful. And so but it doesn't mean that every mediation is going to be successful. And if one side is being unreasonable, and the other side is like, well, do I have to do? No, you don't have to. That's what mediation's about. And so you explain the process of no. And if I'm uncomfortable with a situation in mediation where I think one side is being bullied or trying to be pushed into something, then I'll say no, this mediation's over.
You can say that.
I will say that.
And there are times when I imagine even if it's to be mediated, if it gets a little hot, is part of your job as a mediator to decompress and cool them down?
I will do that. And again, we separate and caucus in separate rooms, and we'll do that to try to not get to that level where we have to do that. But if I really believe there's overreach, because mediation can only be successful if both parties have equal bargaining strength and equal positions. And if one side is overreaching or, being abusive even to the other side, that's the end of mediation. We're not going to go forward with it at that point.
And how does that work with arbitration then, David? Does that always have to seem equitable? Because sometimes the bigger gun is the employer, the corporate official versus the little guy, whoever the little guy is or whatever the little company might be. How does that work?
So arbitration's just like a trial. Both sides have the equal ability to present their case and let the decider, the arbitrator, know what it is that is their position and what evidence they have to support that position and what it is that they want as a resolution. And the arbitrator will listen to both sides. I don't know of any arbitrators who would ever be bullied or overwhelmed or thought that they needed to favor one side or another based on who the parties in the arbitration are.
Do parties in arbitration also need to have a lawyer to best present their case or help them best present their case? Is that advisable?
I think so, because a lawyer will have a better understanding of what the rules of evidence are. Even though they're relaxed to some degree, you still have to know what they are. They'll have a better idea of what information or evidence you need to prove your case. So depending on what type of case it is, I'd say yes.
For people who are involved with consumer arbitration, you have
then
a
I'd say no for lawyers.
Okay. In that case, why would you say no?
Because if it's a consumer arbitration, generally, and I was just being a little bit facetious,
yes,
but generally, if it's a consumer arbitration, it's a smaller matter in terms of
yes,
the value of what's being at stake, and I wouldn't advise spending the money necessarily on an attorney that may cost more than the issue at stake.
Can they still be representing themselves well enough with proper documentation against the guns?
I would say so.
Good to know. I guess the only other question I have is panel versus one arbitrator.
Arbitrator. Yeah.
Is that a difficult thing to decide? How does that get decided?
It depends
quickly?
on the type of case. So certain insurance contracts require a 3-panel arbitration.
Okay.
Others don't. It's usually one. And so the parties, if there isn't a requirement, can agree upon how they want it to be done. And so picking a 3-panel is usually one side picks one arbitrator, the other side picks their arbitrator, and then the 2 arbitrators pick the neutral.
Good to know, because that was one of the questions that was asked. We hope that this has been helpful to you in giving you some insights into how the process works, and perhaps it may work for you. Thank you for tuning in to The Law Matters. As we say, stay tuned, the law matters to you.